Hey everyone, I'm Mr. Willis, and welcome back to You Will Love AP Gov. Thanks for joining me for another video on one of the required foundational documents for AP US Government. This one's all about the United States Constitution. If you're taking notes for your AP class or prepping for the AP exam, remember to click on the link below and download the free guided notebook page to make it easier to follow along. Let's get into it. In 1787, delegates from 12 of the 13 states convened in Philadelphia with the original goal of revising the Articles of Confederation. However, they soon decided to draft an entirely new constitution. The Founding Fathers aimed to create a balanced system that would strengthen the national government while preserving the rights of the states and individuals. The new constitution established a federal system with checks and balances, aiming to prevent tyranny while promoting effective governance. It was signed in September 1787 and eventually ratified by the states, laying the foundation for the American Republic. The Constitution is structured into three distinct sections. First, the preamble, which outlines the overarching goals of the new government. Next, 7 separate articles, each of which serve a distinct purpose. Articles 1 through 3 establish the 3 branches of government, and Articles 4 through 7 touch on issues ranging from the relationship between states to the supremacy of national law to changing and ratifying the Constitution. And finally, the 27 amendments or changes that have been made to the Constitution since its ratification. The first 10 of these amendments are collectively known as the Bill of Rights and place limitations on the power of the federal government in an attempt to guarantee the protection of civil liberties. The Constitution begins with the preamble, which serves as both an introduction and a mission statement, explaining why the Constitution was written and what the founders hoped it would achieve. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Those 3 famous words that begin the preamble, we the people, reinforce that the American people themselves approve of the Constitution and the government it establishes through the principle of popular sovereignty. The rest of the preamble lists the goals that the people of the United States hope to accomplish with their new government. The desire to improve upon the Articles of Confederation, the creation of a fair legal system, the maintenance of peace within the country, the need for military protection, a greater economic and social well-being, and the preservation of freedom for future generations. Although it's just an introduction to the document, the preamble grounds the entire Constitution in Enlightenment principles and democratic ideals. In order to accomplish these goals, the framers of the Constitution looked to create a new government that could stand the test of time. To ensure that the new government was strong enough to govern effectively, yet limited enough to safeguard the rights and freedoms of its citizens, the framers turned to the Enlightenment idea of separation of powers, championed by Montesquieu. By dividing the government into 3 co-equal branches with distinct enumerated powers, they ensured that no single entity could wield unchecked authority. Article 1 of the U.S. Constitution establishes the legislative branch of the federal government. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Unlike the government under the Articles of Confederation, which consisted of a unicameral legislature, Article 1 creates a Congress that is divided into 2 chambers, the House of Representatives and the Senate, forming a bicameral legislature. Representation in the House is based on population, with members elected every 2 years directly by the people of their districts. The Senate, on the other hand, provides equal representation for each state, 2 senators per state, who were originally chosen by state legislatures, but following the 17th Amendment, are now elected by the people of each state. This structure was a compromise between large and small states, balancing population-based and state-based representation. Article 1, Section 8 lists the enumerated powers of Congress. These include the power to levy taxes, regulate commerce, declare war, confirm presidential appointments, control spending, coin money, and issue patents and copyrights. Section 8 of Article 1 is also the source of 2 very important clauses in American government. The first is the Commerce Clause, which authorizes Congress to regulate interstate and international trade, and has been a foundation for federal economic and civil rights legislation. The second is the Necessary and Proper Clause, which is often called the Elastic Clause, which gives Congress the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This has led to the creation of the implied powers of Congress, which are powers possessed by the federal government that are not explicitly enumerated in the Constitution, but are essential to execute expressed powers. Historically, the Elastic Clause has allowed Congress to assume implied powers and expand its reach to adapt to new challenges, such as establishing a national bank, implementing a military draft, and creating regulatory commissions. Article 2 creates the executive branch, which is headed by the President of the United States of America. The President is a single chief executive responsible for executing and enforcing federal laws. Article 2 outlines the President's primary responsibilities and enumerates enumerated powers, including serving as commander-in-chief of the military, granting pardons, making treaties, appointing ambassadors, Supreme Court justices, and other officials, and delivering the State of the Union address to Congress. Article 2 also states that the president must take care that the laws be faithfully executed. This is known as the Take Care Clause, and it explicitly states that it's the duty of the president to ensure the laws passed by Congress are enforced. It also holds the president liable for the actions of his cabinet, executive officials, and members of the federal bureaucracy if they fail to enforce federal law as Congress had intended. The president's power has grown over time beyond the original scope of Article 2 due to historic necessity, national crises, and broad interpretation of vague constitutional language. While Article 2 provides a limited list of enumerated powers, modern presidents have expanded their authority through executive orders, signing statements, and unilateral military action. These expansions, often justified as necessary to address urgent challenges, reflect a shift toward a more robust and active presidency, sometimes raising constitutional questions about the limits of executive authority. Article 3 of the U.S. Constitution establishes the judicial branch, stating, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." This creates a federal court system headed by the Supreme Court, with the power to interpret laws and resolve disputes under federal law and the Constitution, and grants Congress the power to establish lower courts, as it did through the Judiciary Act of 1789. The article provides for lifetime appointments for federal judges during good behavior, ensuring judicial independence by shielding judges from political pressures. Although Article 3 is relatively brief compared to the other articles, it outlines the types of cases federal courts can hear, including those involving the Constitution, federal laws, treaties, and disputes between states or citizens of different states. While the Constitution did not explicitly grant judicial review, this power was affirmed in Marbury v. Madison 1803, allowing courts to determine the constitutionality of laws. Article 3 also defines the jurisdiction of the Supreme Court, meaning which cases the Supreme Court is allowed to hear. It states that, in all cases affecting ambassadors, other public ministers, and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. Original jurisdiction means that the Supreme Court has the authority to hear a case for the first time, without prior review from a lower court, and reach a decision on the case. It goes on to say that in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. Appellate jurisdiction means that the Supreme Court can only review and potentially modify, uphold, or reverse the decision in these cases after a lower court hears the case first. Article 4 addresses state relationships and federalism, including the full faith and credit clause, ensuring states respect each other's laws and court decisions. It also contains the Privileges and Immunities Clause, which requires states to treat citizens equally as they travel state to state, and bans states from discriminating against out-of-state visitors. Article 5 outlines the amendment process, ensuring the adaptability of the Constitution. An amendment can be proposed by either a two-thirds vote in both the House of Representatives and the Senate, or by a national constitutional convention called by two-thirds of state legislatures. Once proposed, the amendment must be ratified by three-fourths of the state legislatures, or by conventions in three-fourths of the states, depending on the mode Congress chooses. Just remember, two-thirds to propose, three-fourths to ratify. The Supremacy Clause, found in Article 6 of the Constitution, establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority shall be the supreme law of the land. This means that when state laws or constitutions conflict with federal law always prevails. The clause ensures a unified legal system by binding state judges to uphold federal law, even if state laws or constitutions say otherwise. It also reinforces the authority of the federal government in cases of conflict, and has been proven essential in resolving legal disputes between different levels of government. Article 7 of the Constitution outlines the ratification process, stating that the Constitution would take effect once it was ratified by 9 of the 13 states through specifically elected state conventions. This method replaced the unanimous consent requirement found in the Articles of Confederation, which made constitutional change nearly impossible. The Bill of Rights was added to the Constitution in 1791 to address the concerns of anti-federalists, who feared that the new federal government would become too powerful under clauses like the Necessary and Proper Clause and the Supremacy Clause. These provisions gave Congress broad law-making authority and placed federal laws above state laws, which anti-federalists argued could lead to the nullification of state statutes and the erosion of individual and states' rights. To secure ratification and placate those concerns, Federalists promised to add a series of amendments that would explicitly protect individual liberties. The result was the first 10 amendments, known as the Bill of Rights, which guarantee core freedoms such as speech, religion, and due process, and reserve all powers not delegated to the federal government to the states or the people. This compromise helped unify the country under the new Constitution, while affirming the principle that government power must be limited and accountable to the people. Since the ratification of the Constitution, 17 amendments have been added beyond the original Bill of Rights, reflecting the nation's evolving values and challenges. These amendments have expanded civil rights, reformed political processes, and clarified government power. powers. Together, these 17 amendments demonstrate the Constitution's capacity for change, allowing it to adapt to new circumstances while maintaining America's core democratic principles. And that's everything you need to know about the United States Constitution. You can click here for additional videos for AP US Government. And be sure to check out my videos on AP Macroeconomics and AP Microeconomics as well. If you found this video helpful, be sure to like, share, and subscribe for more content on AP Government and Economics. Thanks for watching. I'll see you next time on You Will Love AP Gov.